Artificial Intelligence, Law and Justice, Session 40. Welcome to this session. This is the final session and then summing up. So in this session, we will do a quick overview of all the topics we have covered in the last 39 sessions and also sum up the overall course content as well as some thoughts for the future. First of all, we need to know that in the last session, we discussed how the developments in AI are likely to impact law and justice in future and the increase of role of technology in law and justice. So since we dealt with AI and law and justice, that perspective is necessary, but then we need to put that in the broader context of technology and law and justice. That is exactly what the last session tried to tell. So to begin with, let us go back to the basics. Let us go back to the first sessions. So the journey so far is like this. We started first with introducing AI, the key concepts, and outlined machine learning and natural language processing in the first session. And then we followed that with the rule of law in the second session, where we explained the importance of rule of law, why it is very important particularly in the Indian context, and then how the rule of law has been endorsed by the Supreme Court is part and parcel of the Constitution of India. So we dealt with the rule of law in little depth, starting from its origins, its historical origins, the evolution of the idea, and then its current stature, both the merits as well as its limitations. Then we also looked at why data is often considered as the new oil or data is gold for AI. And then we looked at various issues in using data for AI, and then the ideas like data purity, how do we conceptualize data in the context of AI, we looked at them. And then we also identified that data and big data are equally important. And then the idea of big data was also introduced. More importantly, we underlined the need that data governance is becoming very important. So after these three sessions, inaugural sessions, we went into some real life applications in AI in law and justice in India. Because we started with the basic introduction and then we wanted to see what exactly is happening in the ground, who is doing what in India. So we started with session 4, where we looked at how the judicial system in India is using AI and then AI based tools, particularly the Supreme Court of India. And then we also elaborated how this should be understood in the broader context of e-courts modernization, and more importantly, why the judicial system in India is embracing AI with lot of enthusiasm, but it's also equally aware of some of the potential issues, the problematic assumptions and the potential harms. That is why the measure is very calibrated, it is carefully done, and more importantly, it is going on a pace so that the system gains the best from it without rushing into too much, so that unexpected problems shouldn't occur later. Then we also looked at how AI in law is being used or being deployed in different circumstances, the emergence of the legal tech in India, the various applications which are available in different fields, and then why AI application law in India is, as of now, is limited, but the huge potential awaits in the future. So both 4 and 5 and 6 and 7 gave us an idea about the use of AI in law and justice in India and indicated that while AI applications in law and justice in India are booming and are increasing day by day, we have not reached a stage where we could honestly and then comfortably say that AI has made a sweeping revolution in law and justice in India. We also identified why this is the current situation and what are the ways the systems can become better. And then we introduced the idea of algorithmic decision making, and then we introduced the idea of algorithm in data earlier. We introduced the idea of algorithmic decision making, and then we also looked at why algorithmic decision making is so hot, so controversial, at the same time part and parcel of the way AI systems work. We discussed the pros and cons of algorithmic decision making. We also addressed what the literature says about algorithmic decision making in AI and justice, particularly in law and justice, and what are the different applications that are being done. So going forward from algorithmic decision making, we went back and then looked at AI from a rule of law perspective. So in sessions 9, 10 and 11, we looked at the implications of AI for rule of law, particularly the way rule of law can be impacted negatively, and then why we need to be very sensitive to the idea of rule of law when we develop applications based on AI in law and justice. More importantly, we raised a couple of things as to whether AI is raising any fundamental questions or fundamental issues of for rule of law. Then we said we need to have an agile, dynamic perspective of rule of law than a static one. An idea that is amenable to the impact from technologies, idea or the practice of rule of law that is sensitive enough and can counter challenge the challenge from the rule of AI on rule of law, and then how AI and rule of law can be harmonized or can be synchronized. So the sessions 9 and 10, 11 opened up a new way of looking at rule of law from a perspective of AI and vice versa. Based upon the algorithmic decision making session which we had earlier, we dwelt in depth into what is algorithmic justice. Because often AI justice, use of AI in justice is nothing but use of algorithms in justice. So the idea of algorithmic justice became very important. We identified the person who promoted or who propounded this idea, and then we said or we pointed out that algorithmic justice, although is a novel and emerging idea, is something that is very important to understand the role played by AI in law and justice. So we went into various theoretical discussions, practical issues, and then identified that algorithmic justice issues are very critical and they need to be attended to and then worked upon with care and with responsibility. So the 13 sessions gave us a good overview or a better understanding of AI in law and justice, both in terms of application as well as in terms of concepts that are also put to practice. Then we moved into a very critical, interesting, emerging, challenging application like AI and copyright. We dealt that in 4 sessions, AI and copyright 14, 15, 16 and 17. And then as I give this lecture, there is a there is a reported news that government has constituted a high-powered body to look at the AI and copyright issues in India, particularly in light of some of the ongoing disputes on AI and copyright. In this session, we dwelt in depth into the use of Gen AI for AI and copyright, the challenges in using the various exemptions and then other rights available in different laws for use of AI so that use of AI is not construed as an infringement of copyright, and then the emerging challenges, particularly why AI poses a fundamental challenge in copyright in terms of authorship, in terms of creativity, and in terms of whether AI can be a creator or creativity and authorship can be attributed to a system or a machine. So those 4 sessions, although were in depth, barely scratched the surface of AI and copyright. So with that understanding, we moved further to AI and patents and patenting. There again, we highlighted that AI does pose a fundamental challenge on various questions like who is an inventor? Can a machine be an inventor? What is inventive step? What is prior art? And then AI questions which are posed by AI also ask us to look at whether AI can be a co-inventor, whether AI can claim that it did come up with something that is totally new and novel and deserves to be protected with a patent, and how different jurisdictions are trying to understand and then trying to deal with these issues. So we put that in the broader context of patents and innovation, and then looked that also in the broader context of AI's contribution to innovations. So the AI in copyrights as well as AI in patent gave us a better understanding that AI has got huge implications for IP rights, particularly in emerging sectors, emerging technologies. At the same time, some of the fundamental problems or fundamental challenges posed by AI for IP rights are too severe or too difficult to be handled by a single case or by a single judge. So we said the field is wide open, and then the future alone will be able to tell us as to what our assumptions about copyright, authorship, inventorship, invention or right or wrong. but AI is there as a paradigm changer, not just as a game changer. Then in this 20th session, we looked into AI ethics. We identified why there is so much talk of AI ethics, although there is lack of clarity on what exactly is meant by AI ethics in theory as well as in practice. We also mentioned in and explained in detail that AI ethics is not something that can be wished away. Why AI ethics is equally important for in deployment of AI, in development of AI, and more importantly, why AI ethics, there is a broader consensus on AI ethics, although the contours of that consensus are not very clear on one hand, and what exactly are the components of AI ethics are also not clear. So, depending upon these issues, depending upon these debates, we dwelt into what are the key components of AI ethics. We looked at the definition or the ones given by UNESCO. We also highlighted and then cited many ethical guidelines, ethics guidelines, including the OECD principles. And we also pointed out that this is an emerging important field which cannot be ignored. Now, translating that into practice is the major challenge. So, we identified what is the role and relevance of AI ethics in law and justice and how this can be translated into practice from theory to practice in law and justice, and how various bar associations, various entities are trying to come to grips with AI ethics by coming up with different guidelines that supplement and complement already available AI ethics guidelines for lawyers and advocates. And then what are the major new issues they've identified? So we said that AI ethics is a supplement and complement to ethical practices, but ethical practices using AI are there to stay. So we cannot simply say that AI ethics can be simply relegated to the background. We can be comfortably dealing with the regular routine applicable ethical good practices. More importantly, we also pointed out that integrating AI ethics in law and justice is not a question of necessity or not a question of sufficiency, but is something that is so fundamental that AI in law and justice will not have credibility and acceptability unless it is perceived to be ethical and it is proved to be ethical. So, building upon AI ethics, we went into an emerging important concept called responsible AI, which again, like AI ethics, is widely talked about, widely discussed. Of course, there is again lack of clarity. Again, there is a question of who decides what is responsible. Responsible AI means what exactly is it? Is it an addition to ethical AI, or is it a substitute for ethical AI, or is it something that nobody knows but everyone talks of? So we went there to look at the emergence of responsible AI, and then we identified that responsible AI became a major factor in light of the developments in the AI field in the last decade and a half so. And then we also pointed out that responsible AI was not something that was thrust from the outside upon the companies dealing with AI or the major players in the AI ecosystem, whether it's Microsoft or Google or Apple or any one of them, even other players also, keenly interested, keenly working on responsible AI, coming up with their own responsible AI principles, guidelines, and then identifying the issues in responsible AI. And we also looked at there is the emerging question of standards for responsible AI. Then we said translating the responsible AI principles into practice involves a lot of things. So how companies are trying to bridge the gap from theory to practice in responsible AI through specific guidelines set by themselves or developed with others, and then how this translates into practice in terms of assessing systems, assessing AI products, and other ways. Then we also touched upon the need for responsible AI in such a way that responsible AI, when it comes to law and justice, cannot be wished away. It is all the more important. So what exactly we mean by responsible AI in law and justice? Is it another version of ethics in law and justice, or is it a new beast which we do not know as to how many legs and then how many hands it will have or how many eyes it will have? We said responsible AI is a new beast, a novel beast, but then the beast that we need to deal with, understand, and then come to grips with, so that we are able to understand responsible use of AI in law and justice. Then we went a step further and then identified what are the issues in putting the responsible AI into practice in law and justice, where we took upon to explain the available ethical guidelines or the playbooks from two important players, that is NASCOM, the industry representative, to highlight one stakeholder, and a civil society to highlight the perspective from another stakeholder. Then we used the case study from Niti Aayog, which dealt upon the responsible AI principles, particularly in the Indian context, and then used facial recognition technology as an example to identify both the issues and challenges and the potential for responsible AI deployment in India, particularly in that application. So these three sessions, in fact, gave us a better overview of responsible AI as a concept, particularly as applied to law and justice. So after dealing with ethics, after dealing with responsible AI, we went further and then talked and then discussed about explainable AI. Now, ethics in AI, ethical AI, responsible AI, explainable AI, are all these mere jargons, or are we filling up different fields or different topics with jargons picked up from here and there, and then trying to put together a bricolage or give a kaleidoscope or something like a khichdi where you can mix anything with anything or anything goes with anything? No. We said that explainable AI is very different from responsible AI, although there could be overlaps. Again, explainable AI cannot be simply brought into ethics in AI, because explainable AI has got a wider scope. And then why explainable AI is important in AI applications per se, and then more exactly what is the need for explainable AI. Or we also put the question that explainable AI cannot be an afterthought. Explainable AI is not something that can be substituted for much thinking and action when we develop systems. So the key issues in explainable AI were brought in, were discussed, and then how to implement them or how to translate them into practice also discussed. Then in particular in law and justice, how to realize this explainable AI, we discussed in detail. We also identified the key challenges and then the potential issues. So the sessions 25 and 26 did tell us that explainable AI is not an utopian ideal, or is a free floating idea that is floating somewhere here, somewhere there. Some people say, I have seen it. Some people say, no, I have not seen it. Some people say, no, it is something like a amalgam of lion and tiger. You look at it one way, it looks like a tiger. It looks like a lion from you look at it from another perspective. No, we said explainable AI is a clear-cut, concrete example of a practice and theory that will be part and parcel of law and justice in the days to come, if not now, in the full scale. So the sessions which we discussed, ethics, responsible AI, explainable AI, form the trinity of ethics and responsibility and explainability in AI, and this trinity will be at the core or at the heart of any discussion on AI and law and justice, when we really want to understand how society should harness AI for law and justice. So this trinity, or what we have called as trinity, is something that will always be looked into whenever we talk of AI, or whenever the AI systems are deciphered or deconstructed or identified for some issue or identified for some sort of analysis. So by that sessions, we have looked in the vast application of AI. We looked at a lot of theories, we looked at a lot of practical examples. We also dwelt in conceptual level like algorithmic justice. We dwelt into responsible AI and all. This is a course on AI and law and justice. But a mere understanding of AI and law and justice will not give us a good understanding of how AI is impacting law and vice versa. Or in other words, to get a better and fuller understanding of AI's implication and impact in law and justice, we need to look at how AI is impacting at least a few other fields of law. So we chose 3 other fields of law just to highlight that AI's impact, influence, and then the long-term implications are not going to be trivial, or rather AI is emerging as a major paradigm changer in law, and more importantly AI is both an enabler, it's a disruptor, it's a challenger, but it is an innovation that cannot be wished away. So we looked into AI and labor law, particularly in the context of discrimination, in the context of unemployment, and how why AI application labor law have to be very sensitive to ethics, responsible and responsible AI. So we looked at how AI is transforming labor law, and then how some of the questions that arise from the labor law, the fundamental issues labor law deals with, like collective rights, rights of the workers, right to be heard, right to be given opportunity, have to be factored in when we develop systems using AI. Similarly, we went into health law. We clearly said digitization, availability of the digital health records, availability of datafication in health is emerging as a major challenge, and why datafication in health is in fact is fueling application of AI in health, and more importantly AI in health will be a long-term game changer. And across fields in health, AI is going to make a huge impact. So AI's implications for health law is going to be too critical that will be felt more in the days to come. So we came up with some examples. We identified some really interesting examples as to how AI is changing the very idea of diagnostic, treatment and other things. So we identified some of the issues where we said data governance, data privacy, privacy rights, and more importantly, interoperability among data, and then data standards are becoming more issues. Of course, we also dealt about data flows, cross-border data flows in a limited context, but we said that health law is going to be impacted in a major way by AI. Then we took up the discussion of competition law in session 29. As we have discussed about AI and IP in the context of copyright and patent and patenting, competition law is something, AI and competition law is a session that will go hand in hand with them. Although competition law which we talked about is not very specific to copyright or patent. We talked about the broader issues in AI and competition law and identified why AI applications in competition law or use of AI for different purposes raises lots of challenges, new issues for competition law, particularly the emergence and then proliferation of platforms, particularly the emergence of the big tech firms that control a huge portion of the internet directly or internetly, and how the development of e-commerce platforms, how the development of algorithmic price fixing, how the development of algorithmic monitoring of the various activities pose challenge to competition law in terms of new questions and new answers. So we also said that the competition law's twin objectives of promoting innovation and then protecting consumers, and then incenting innovation as promoting competition, protecting consumers' welfare, and then other objectives have to be met by ensuring that competition law is up to date, is agile and dynamic enough to face the challenges that arise on account of AI. So we identified the major issues and then the ongoing discussions on them. Then in session 31, we had a good global overview. In one sense, it was not that we discussed about AI in law, AI in law and justice in select jurisdictions. Rather, we went a little broader, looked at different trends, different new novel concepts and ideas, and then we found or we discussed what is emerging, what is happening, why the field is so dynamic, vibrant, at the same time lot of contestation happens, and why there's lot of feel of unease, unsettled pace or unsettled feeling, and why people who are also very optimistic of AI's role in law and justice are also aware of the challenges. So we highlighted some of the developments. We highlighted how countries are coming to grips with that and what initiatives have been taken and whether the notions of AI advocate and AI judge are mere fanciful ideas or whether they can be realized in the short term. And we looked at that in a very broader perspective of the global level of technology deployment and then the future prospects that could emerge in the years to come, the near future. So session 30 and 31 gave us a sweeping bird's eye view of the developments without dwelling into too many details or bombarding the listener with too much of data. Then the next three sessions dealt with three critical stakeholders or three critical aspects. That is how AI is transforming the judicial process, the potential for AI, generative AI tools, and then how carefully they need to be factored in, and then the pros and cons of using them for judicial decision making. We also highlighted that they are not going to diminish the role and responsibility of judges. We also highlighted that in case of some high risk cases, rule of generative AI tools has to be done with a lot of care, and it is better to avoid use of AI in case of some high risk, high profile cases where human judgment can be a better tool than using AI. So we looked at different options, we highlighted some factors there. So we came up with some preliminary conclusions on the topic. Then the next session talked about AI's implications for human rights and why AI's implications for human rights are to be fully understood, and particularly in context of fundamental rights, and then the implication of AI for other accessory rights. So we highlighted that AI's implications for human rights cannot be wished away. At the same time, we should ensure that AI systems respect human rights. They do not prima facie violate human rights or enable violation of human rights. So there we brought in the idea of external AI, responsible AI in the broader context of human rights. Then we discussed about the legal education and then how AI will impact legal education. There we brought in the sustainability dimension of legal education, and then we said that environmental justice, climate justice matters also equally important when we want to look at the implications of AI for legal education. And then our discussion on AI and legal education went beyond looking at legal education as legal education. We highlighted the need for sustainability being a factor there. We highlighted the need for the risks and challenges in trying to integrate sustainability as well as AI and legal education. So these three sessions, AI, judges, human rights and legal education, broadened our understanding, went beyond what we discussed in responsible AI, expectable AI and ethics AI, added a new dimension in terms of application of AI in law and justice. So by now we have a fairly good view that while there is huge opportunities are available, the challenges are also too vast, too difficult to be simply reduced to a few issues of here and there. Then we looked at the AI's implications for constitution. We did dwell about constitution briefly in the discussions on rule of law and AI and rule of law. But in sessions 35 and 36, we went overboard, we went beyond that, and then we discussed at a in-depth discussion on how AI can impact constitution, what are the implications of AI for the constitutional morality, constitutional scheme of things, and then how AI can challenge some of the fundamental constitutional assumptions about rights and responsibilities. So we said, or rather we pointed out that AI's negative impacts on constitution should be taken into account, and then we should also try to see that AI systems do not openly or prima facie violate constitutional norms, and then they should respect constitution. So these two sessions added weightage and value to the previous discussions on human rights, education, and also the ones which we discussed earlier, ethics, responsible AI, and then external AI. So whenever we talk of judges or education or human rights or external AI or constitution, or for that matter, even on responsible AI, we know that some things seem to be recurring. Some fundamentals will always be there. So we need to look at them when we talk of AI in the context of law and justice. So having come this far, having covered 36 classes with a broad overview and then looking at depth many of the issues, we then put the next three assets together one, focusing centrally on innovation future. As to where do we put AI in the broader context of law, legal technology, law and innovation and future. And then we dealt in three lectures, law, justice and innovation. What is happening? What is the trend? Of what direction they could take? And what are the major issues and challenges? Then we dealt with AI and techno-solutionism. We introduced the concept of techno-solutionism here, although we had in passing discussed that in an earlier session. More importantly, we said we should not go by AI hype, nor we should take a very critical, cynical, negative perspective on AI's application in law and justice. I highlighted the basic fact that when we talk of innovation, we should bring in new ideas like equitable access to AI in law and justice. We talked about democratizing access to AI. We talked about democratizing access to AI technology, and then what sort of new tools, new approaches would be needed to realize these in practice. So the session 38, in one sense, built upon what we discussed in 37, but in other sense, it introduced new ideas. More importantly, it also talked about a new angle that don't conceptualize AI as a super technology. Look at AI as a normal technology. But what is the idea of normal technology? That also we dealt with, and then we said don't go for IP or don't go for negative, impossible criticism. Rather, strike a middle way path so that we understand AI as a normal technology, a technology that is going to make huge impactful changes, but not a technology we should hype about, not a technology we should simply try to discard or look with disdain. So this is an antidote, or this is a counter move to the textual solutions perspective, which is often not explicit but implicit in lot of the papers, lot of the literature on role of AI in law and justice. So building upon 37 and 38, we dealt with technology, AI in future of law and justice. We again came to some very interesting preliminary findings and conclusions, where we again dealt upon some of the potential issues that could arise, but also the huge potential that awaits AI and then the bright future of AI in the context of law and justice. So after going through 39 sessions, in this session we are summing up, we are coming to the final one, where it is time to wind up, but also time to look back, identify the major takeaways. So I will quickly list a few takeaways from these 39 sessions. One, AI is playing an important role in law and justice. This is obvious. We have given too many examples. Data and rule of law are key themes that need to be taken into account in AI law and justice in India. This also we have explained why it is necessary. We have said the scenario in India is quite encouraging and promising, but then we need to go a long way in fully harnessing AI in law and justice. This is again truism, but we have gone in depth into why we are saying it. Then we said translating applications of AI applications into law and justice into that field is more than just developing technical systems. They need to be ethically sensitive, they need to be responsible, they need to be expendable. So we time and again we pointed out that don't look for the techno solutions perspective, don't look for the techno fixes, or try to understand a holistic things in a holistic perspective. Then we also discussed about the AI's impact on rule of law and use of algorithmic decision making, how this challenges the fundamental issues, fundamental assumptions in the law and justice, particularly the way courts and judges function. We also felt that why there's a renewed and the new calls for algorithmic justice, and what exactly is meant by algorithmic justice, and how realizable is that in the context of deployment of AI in law and justice. Then we said how AI is a game changer in copyright and patent, raising fundamental questions. We say that some of them have been addressed, although inadequately. Many of the things have not been fully unresolved or have not been even addressed fully. We also said courts have come up with decisions, but the picture is far from clear. Then we talked about AI ethics. We also, the major takeaway is here. It cannot be an add-on. Explained by AI is equally important. Translating AI, responsible AI into practice is a big challenge we have to be faced. Then we need to look at the three ethics, explained by AI, and responsible AI as the core of any thinking on any practice in AI or for AI in law and justice, or bring them to the core when you build systems, when you want to understand systems, or when you want what exactly you want to achieve in AI, using AI in law and justice. So with this trinity or the triumvirate which we time and again have been telling are so important that they cannot be simply wished away or ignored. If we do that, they will come back to haunt us with vengeance, and then we will be paying a very heavy and dear price for it. So the implications of AI for different branches of law we have discussed. So we also found that the responses are novel. Some of them are coming to terms with that. Some of them would need a calibrated approach. But then lots of questions remain unresolved or not even fully understood. So we need a calibrated approach that is agile and with the understanding that technology raising fundamental questions and blurred boundaries. Or we will learn more as we go further. Assumptions are still there, presumptions are still there, but then so are doubts and confusions. So approaching AI in different branches of law is itself a challenging venture or challenging exercise on its own in each branch of law. So we gave a quick view of the AI in law and justice and elsewhere in law, that why the application of AI is not uniform, why there are so many unresolved issues, and then how the different stakeholders are trying to come to grips with them. And then the challenge AI poses judiciary and why there's a dilemma in that. Then we talked about human rights, education, constitution, we talked about the constitutional values, and we also went into these last three sessions where we brought to the core the need for innovation, caution, and then looking at future with optimistic or with a cautiously optimistic perspective. So with that, we have wound up 39 sessions, but we covered many themes and topics, and the coverage is that most of the time we have introduced a theme and scratched the surface, although we did go into depth in many of the themes. Then, in a course of 20 hours and 40 sessions, we have to try to do justice to the themes by highlighting key issues and concerns and looked at responses. But obviously, there are limitations for such a course, but then that is inevitable. There are certain things which one has to really deal with and then be prepared to deal with. And in this course, as much as possible and to a great extent, I have relied upon the most relevant and most recent literature. And then to give a broader global perspective, I have not taken, except in sessions where it is required, a typical Indian perspective or a perspective that is aligned to the Indian context. Rather, the course or the idea here is that we look at things in a broader way, because AI is a universal technology. AI is going to be there in law and justice systems across the world, across jurisdictions, across different branches of law. So we need to have a broader, wider, at the same time an in-depth understanding of the emerging issues, emerging challenges, or the challenges posed by AI to us, and then how different institutions, different regulators, different countries, different parliaments are trying to come to grips with that. So in that broader, wider perspective with an in-depth understanding, we tried to fix or to put this course. So with that broader objective, this course was designed. So there are limitations, there are things which one would have dealt in more depth, but one couldn't on account of time limitations. There are some cases where some case laws were not discussed in full or in greater detail because time was limited, but the key essential points and findings were highlighted, and more importantly, almost in all the sessions, literature was also given as part of the PowerPoints or discussed as and when the literature was mentioned. So these are some of the things please keep in mind when you undergo this course. I hope that more importantly, if the course has helped those who have taken it to get a better understanding and kindled interest in knowing more, that itself is a positive and welcome sign. It could be sort of a interesting journey. It could be giving you a better understanding. It could be something which you would like to passionately pursue more, or it could be something like where you found that this is good enough for me to understand for my level of AI related work, or for my level of using AI in the field, or as a general student or as a general academic, I find this course is good enough for me to pick up things later. So, whatever may be your objective, whatever may be your expectation, I hope that this course has more or less fulfilled them and has given you a lot of things to think about, lot of things to chew about, and more importantly, lot of new ideas, new concepts, and then new ways to think about to explore further. Your suggestions and comments are most welcomed. They will help us to improve this course further, particularly if it is going to be offered in the future, and also to design similar courses with more advanced introduction and advanced in-depth discussion on some of the issues like IP, competition law, responsible AI. To be frank, in my view, doing a 20-hour course on responsible AI, designing such a course is also feasible. But again, there are limitations. Again, there are so many ifs and buts and then pros and cons. So what happens in the future, we cannot predict now. So as of now, the course is available to you to test, to try and to learn. Thank you.